Okay, we're live on YouTube.
Okay. Good afternoon, everyone, and welcome. My name is Christian Hansen. I'm the North Logan City Appeals Officer. We're here today on an appeal or application for appeal filed by Joel Hopkins that's dated February 10th, 2023. Mr. Hopkins appeals from a notice of decision dated February 3rd, 2023, specifically with request to the Planning Commission's denial of his conditional use permit as it relates to an accessory dwelling unit. This hearing is being held within 30 days of the application for appeal filed by Mr. Hopkins. Mr. Hopkins bears the burden here, so my intent is to hear first from Mr. Chambers. I'll then hear any response from the city, and then I'll allow Mr. Chambers a chance for a brief rebuttal. So we'll proceed in that manner. Yeah.
My name is Joe Chambers. I represent Joel and Eli Hopkins, both who are the appellants as to the decision. It's tough to make a presentation when the other side hasn't given you a response back. And so one of the things I try not to do is just simply reiterate what we've already set forth in the appeal. One of the items that I think that will carry the day or should carry the day is the recent decision in the North Monticello Alliance versus San Juan County case, decided February 16th, 2023. And it adds, there's an aspect about land use law that you learn something new every day, no matter how much you know about it. And this case, when I read it, added a nuance to what the findings actually have to be, written findings and written conclusions. And I think on that basis alone, the decision of the Planning Commission, and I understand they're lay people that are on the Planning Commission, but these are legal standards that are laid down by the court system as to what the legislation behind this means. And for a decision not to be arbitrary and capricious, the Court of Appeals has set a new higher bar up that requires written findings and written conclusions of law. And in this particular case, I don't think the record has anything. And on that basis alone, I think the Planning Commission's decision is arbitrary and capricious and requires that the decision be overturned. The more interesting aspect to me is, in the absence of the North Monticello Alliance decision, is what does the ordinance mean? And if you reviewed the record, you can tell from that evening that the public and the staff who wrote the report and the commissioners were all looking at it a little bit differently, and we have obviously latched on to the staff report because we believe it shows the historical application of the ADU. They recommended approval of this and that it complied with the ordinance. There's a lot of discussion in terms of whether or not the structure is larger than the maximum gross area of 1,500 square feet, or the ADU, the accessory dwelling unit, meets the definition as the staff report finds it. And I addressed it in our position statement that one of the things that we're asking this body to do, the appeals authority to do, is to not stop and just simply rely on the North Monticello decision and remand it back, but to also give some guidance. And we're recommending that the appeal authority adopt the position of the staff and the city in terms of what the ordinance means. And
Can I stop you right there for
Sure.
a minute? So I'm looking at Utah Code Annotated Section 10-9A-707 that really kind of defines my responsibilities, at least as I understand them. And I really view them as twofold here. First, I understand that my scope of review of the factual matters is on the record, and I have to find that there's substantial evidence for each essential finding of fact. I think I understand your argument with respect to that, especially in light of this Court of Appeals case. But then two, I have to determine the correctness of the land use authority's interpretation, application of the plain meaning of the land use regulations, and interpret and apply a land use regulation to favor a land use application unless the land use regulation plainly restricts the land use application. So my question is this, can I do what you just asked me to do if I don't have the written findings of fact and conclusions of law? Like, because what do I then have to analyze? What do I base my decision on if I don't have written findings of fact and conclusions of law? So that's where I'll just tell you, that's where I'm struggling getting to phase 2 of the analysis that you've asked me to do.
And I appreciate that because without this having an interactive discussion, I may be addressing things that are totally irrelevant to you. And I want to make a presentation that addresses your concerns.
Can I ask both gentlemen to speak more directly to the mic and a little bit louder?
I can't. I'm actually losing my voice. I'll move the mic closer to me. I'm going to give you a long answer on this, and I don't mean to. I used to be chairman of the Providence City Board of Appeals, and I recall an instance where the applicant appealed for a variance, and the city did not oppose it, and we granted the variance. The mayor asked me to meet him in his office afterwards and was concerned. And I explained to the mayor that we operate under an adversarial system of judgment of law in this country. We're not like Spain or France where there's an inquisitor position, and that normally a judicial officer, and you are a quasi-judicial officer. I was a quasi-judicial officer acting in that capacity. I don't make up the arguments for the other side. I deal with the arguments that are there. And you know, I didn't bring any case law authority for that, but it's well settled that the judges aren't there to advocate for a position. So I think the first thing you need to do is you need to step back. I respectfully suggest you would need to step back and say, okay, the city has not responded on this, and I don't think you address arguments that aren't presented to you. Second of all, I think we did address the ordinance and talk about it and how it's been applied historically, and the way the staff report has applied it is the ADU structure qualified because it was 1,500 square feet or less. Now, I understand the way the ordinance reads. It's confusing as hell, to be honest with you. But then you have to go down and look at that and say, would a reasonable legislator enact that? And this ADU ordinance has morphed over a period of time. I think as I've seen the ordinance, and if I got this wrong, and I'm not trying to intentionally misrepresent it, but it started out as basically an ADU, and it wasn't defined as an internal or an external, but mainly they were dealing with internal ADUs at the time. And then the city council saw a need to modify it, and I think it's been modified twice, So now the internal ADUs are in one section of the city code and the external ADUs are in another section. And the intent of the city council clearly, to me, is the same way that the staff read the report and found it to be qualified. That as long as the ADU is not in excess, the external ADU is not in excess of 1,500 square feet, then they qualify. And that's why the staff recommended that it be qualified. And I think that's entirely consistent with what the North Logan City Council was adopting and wanted to control for their external ADUs. Does that?
Yeah, but I guess, I mean, and I'm not trying to make anybody's argument. I have a job to do here. And quite frankly, I'm looking to you to maybe provide me a little bit of guidance, or to just use you as a sounding board to see if I'm off base here. Because if I go back to this Monticello, this recent Court of Appeals decision, I mean, this is what's expected of the written findings. It says on, and I realize we're talking about, this is in reference to a Court of Appeals, but I don't think it matters for purposes of what I'm asked to do here today. It says on appeal, a court can perform its duty only if the land use authority has created findings revealing the evidence upon which it relies, the law upon which it relies, and its interpretation of the law. So of those three, quite frankly, I'm clear on one. I'm clear on the law that was relied upon. What I'm struggling with is, how do I review the decision where I don't have their interpretation of the law, especially where it is a confusing provision in the municipal code? I mean, I have references in this code to a detached accessory dwelling unit, a detached dwelling, a single family dwelling, a primary structure, and an entire structure with no definitions. And so I'm left to read this and go, what did they determine to be the primary structure? What's the entire structure in reference to an attached accessory dwelling unit, the detached structure, or the detached dwelling unit? I'm confused. And so you want me to get to this second phase of the analysis, but I don't know how I can really do that without understanding what findings they made in that regard.
Well, maybe I didn't communicate it. I don't think you have to get to the second phase in order to address the conditional use permit.
But didn't you ask me to, if I get hung up on the findings of fact, you want me to further my analysis?
I want you to, my understanding is the appeal authority has the ability to interpret and apply and define what the ordinance intended. That's normally been the function of an appeal authority. If there's a question, if it's ambiguous, then the appeal authority goes ahead and says, this is what I am telling you the ordinance means. And that's what I'm saying, is that I would like you to adopt the staff's recommended interpretation of the ordinance as that so long as the external ADU is 1,500 square feet or less, that's what the North Logan City Council intended. And if they didn't, they can go ahead and modify the ordinance. But I agree with you. I have to tell you, after 40 plus years of reading this, and I'll tell you, land use law, if you think you've got a handle on it, you're fooling yourself, because it is a complex area of the law, and it's changing every time the legislature goes into session. In this particular case, the staff, I think, was in the best position to know how the city was interpreting their ordinance, and I think that's the ordinance. That's how this body should define what the ordinance means, so that we don't come back here for a second go around after the planning commission decides they want to make extensive findings and conclusions to bolster it. It just seems to be the prudent and most economical way to do it. Does that?
Yeah, I understand what you're saying now. I appreciate that. Thank you.
Okay. I don't want to belabor it, but do you mind if I ask my clients if they have anything else that they would like to add that I've maybe missed?
Go ahead,
Gentlemen?
that's fine.
Okay, thank you.
All right, thank you. Anyone from the city that wants to address the appeals officer?
Scott Perks, Community Development Director, North Logan. I don't know that I have anything to add to it. My understanding through North Logan City Code on this process is that it's somewhat limited in its scope of review to the record. It's not a review de novo. And so I don't know how much I can add beyond what is in the record, or how much I should add that is beyond the record.
Can I ask you some questions? Because I agree, we're limited to the record here.
Sure.
I've reviewed what's been submitted to me as the record. I've reviewed the audio from the hearing. And so my question to the city is, where are your written findings of fact and conclusions of law?
Sure. And without trying to speak for the Planning Commission, although I was present during that proceeding, the motion was intended to have that finding. And the finding in the motion, I believe, is that the entire structure was larger than 1,500 square feet. And their review of that anecdotally, and I think this is supported in the record, is that they looked at the entirety of the structure, all four walls, and the ADU being a portion of that structure exceeding 1,500 square feet. That is how I would take it if I were to read the record and were to try to interpret for them that finding that is in the motion.
Okay, and I'm going to be really transparent here, because I had the same question to Mr. Chambers, but the instruction from the Court of Appeals is that the reviewing entity, whoever that may be, whether it's an appeals officer or a Court of Appeals, can perform its duty only if the land use authority has created findings revealing the evidence upon which it relies. Arguably, I could stretch and find that in the notice of decision as to the square footage and whether it applies or doesn't. The law upon which it relies, which I'm pretty clear on the municipal code section we're relying upon here, and its interpretation of the law. And that's where I'm really struggling on this, because I don't know how they made their way through this code section, to be totally honest with you. That I just don't have a connection as to what did they interpret, because like I said to Mr. Chambers, there's so many different references to so many different types of structures that I don't know which is which. And I feel like I can't really do my job unless I have an understanding of how they interpreted that provision of the municipal code. That's where I'm really struggling, because the next phase of my analysis is I then have to determine the correctness of their interpretation and application of the plain meaning of the land use regulation. I think that's why we have this instruction from the Court of Appeals, is if I don't know how you interpret the law, then how do I make a decision as to the correctness of that? And then I have to determine, did they interpret and apply the land use regulation to favor a land use application that, unless the land use regulation plainly restricts the land use application. So that's where I'm really having a hard time on this one, is I don't know that I have the written findings as to how they interpreted the law to then go to the next phase of my analysis. And I don't know if all I have are, if the city's saying, look, we have what's stated in the notice of decision, that little paragraph blurb that basically reflects, I believe it was Mr. Coleman's motion.
Correct.
And that's that. then that's what I will rely upon in making the decision on this case. I just want to know if I need to be looking at anything else from the city's perspective.
No, so as far as formal written findings and conclusions, I think that you're correct. What is in the record as far as the minutes and the recording, there were some discussion as to the ambiguity of the language, and some discussion, I believe, Commissioner Coleman had mentioned he has to interpret the language as it's plainly written. So that's spoken through the record, but not written on a formal written notice or a formal finding. So you're correct. There's not bullet pointed findings that is on a document to provide in this instance. And I guess from a format perspective, what would such a document look like? Traditionally, is this in a notice of action or an action notice where it's then bullet pointed? Is it made in dialogue through the planning commission that it's clear in the record as dialogue supporting the motion that was then passed? That's where how do these findings make its way formally into a record?
I don't know if there's a general
A set procedure.
rule or, I've never seen that. I think what's important is, to me, the best instruction is from the Court of Appeals, where it says the reviewing entity or authority can perform its duty only if the land use authority has created findings revealing the evidence upon which it relies, the law upon which it relies, and its interpretation of the law. Now, because I'm law trained and live in this world, the way I view that is going to be different than how the Planning Commission views that.
Sure.
And I'm not going to expect the Planning Commission to do what we expect from a district court judge when they make findings of fact and conclusions of law. But at a minimum, I need, especially when we have a municipal code provision that is as confusing as this one that's at issue, and I'm referring specifically to 12C 515.2 subparagraph 3. I just don't know. I mean, that last sentence, if the accessory dwelling unit is built entirely over a garage for the primary structure, the entire structure shall not exceed a minimum gross area of 1,500 feet. Here's where I struggle. I know what the accessory dwelling unit is. What's the primary structure? Because typically what we're talking about is the accessory dwelling unit and a single family residence. Those are the two structures on the property that we deal with.
Mm-hmm.
Well, if you're asking me which one's primary, I would default to the single family residence, because in my mind, the primary structure is the main one and the accessory dwelling unit would be a secondary structure or not primary structure. But that's not clear to me here. And the reason it's further confusing to me is under this section, we're dealing with detached accessory dwelling units, which would suggest to me we're not dealing with the primary structure. So I'm really confused. And I don't have any indication as to how the Planning Commission went through and decided that that last sentence even applies. Because quite frankly, I think it's out of place. I don't think it's meant to be in the section on detached accessory dwelling units, because I read that to say if it's an accessory dwelling unit above a garage in the single family residence, because that to me would be the primary structure. But I don't know that. And so I really, really struggle, and I'm not going to go. It's not my job to make those decisions. My job is to rely on the record made by the Planning Commission and their findings, and then to apply 10-9A-707 to determine if they did it right or wrong. And I just don't feel like I have that. And if the notice of decision and the findings contained in that notice of decision are all that I have to rely upon, then I don't think I have substantial evidence in this case. And so that's where I'm at. I mean, I need more from the Planning Commission. I really do on the findings of fact and conclusions of law. And so that's a long way to answer your question. What does it look like? But that gives you some insight as to what my job is and what I have to analyze. And specifically with respect to this section of the municipal code, that's the challenge I have.
That's understandable.
Do you have any other questions or any other input based on that conversation?
No, I think based on the planning commission's decision and their discussion throughout the night, I mean, there are lengthy minutes that have dialogue from those planning commissioners that talked about how they read the language, how they also were confused about it, but how they deciphered it and ultimately ended up with the motion that they had made. Now, those aren't specifically mentioned on that notice of decision in bullet point form. It's not referenced to in the motion saying, here are the findings to support my motion. So from a format perspective, you're probably right. It's not compiled in an easy to read format.
Well, and here's my response on that is I can't go through and listen to that and decipher, because there's a lot of discussion there. I mean, there's a lot of discussion about Airbnbs and HOAs, and all of that stuff I think falls outside of the purview of what I'm looking at. And so if I just listen to that, then what specifically did they rely upon in making their findings? So it's great to have the discussion, but I feel like there needs to be some consensus by the planning commission at the end. Like, okay, we discussed all of this. We know we can't consider these things. So this is what we're basing our decision on. Because, the appellants point out, they raise this issue of public clamor, which I think is a legitimate issue here. If I listen to the audio, is even the planning commission, some of the concerns, I mean, not only the Airbnb issue, but there was also the issue of, well, they're living in the accessory dwelling unit, not the single family residence. And we're concerned about the flip there. And, I don't think that was a finding they relied upon, but that was a discussion. But that's just an example of why I can't go through and listen to the audio and then say, okay, these are the findings they relied upon, or this is how they're interpreting the code, because quite frankly, none of that has anything to do with the relevant section of the code here in this case.
Correct. There's a lot of dialogue for ancillary topics of discussion. My recollection of the meeting and going back through the minutes and rewatching the recording, there was a lot of that distracting discussion. However, I do believe that the planning commission did ultimately fall on a single finding, which is then in the motion. They had these ancillary discussions, but when it came down to brass tacks, they said, we do not approve this based on the fact that we believe the 1,500 square feet is in excess of what the code allows. The structure as a whole is bigger than 1,500 square feet, even though the dwelling inside may only be 1,500.
And that's where I struggle with the finding as to their interpretation of the statute or the code section.
Correct.
Because I don't get any of that. I need an explanation of how they're interpreting, because that's a tough statute to interpret, or that's a tough code section to interpret.
Yeah.
And so I sympathize with anybody that has to go in and assign what those things mean. And, I think the other thing we have to be mindful of here is that they have to interpret and apply a land use regulation to favor a land use application, unless the land use regulation plainly restricts the land use application. So if you want something to plainly restrict a land use application, you better have a pretty succinct and clear section of the municipal code that you're relying upon. At least that's my thought.
No, I agree.
But I'm honestly, I'm not getting to that prong of the analysis here, because I don't feel like I have the findings to be able to do that.
Yeah. So my recollection is that there was some discussion on that square footage component, which ultimately was the finding in the motion. But there wasn't a motion taken. Do we all agree that this is the interpretation? Yes or no? So there wasn't that pause in the meeting to say we are all in alignment on the interpretation of this statute. And then the meeting would then further go on to then use that finding as part of the motion. So there was not that definitive, we all agree on this aspect and how we are reading and interpreting this, subsection 3, talking about the square footage.
Okay. Anything else?
We do have a couple of planning commissioners who are in attendance. Not sure if they're able to provide more than my recollection as a bystander in this discussion. They are available if that is helpful in your interpretation or understanding the intent behind their dialogue.
Well, my issue isn't the intent behind their dialogue. My issue is I don't have it in writing to review.
Correct. No, I understand that.
And so it probably doesn't help me as far as what my purpose here is today. I hope this conversation is helpful to them so they can better understand.
It is a learning
And look,
experience, sure.
This Court of Appeals case we're talking about came down February 23rd, and it does cite some older cases. I don't think all of this is brand new stuff, but I think it's really instructive and it gives a really clear expectation of when you're making a land use decision, this is what you need to do.
Sure. And I think it's educational for all of us involved in these proceedings that lead up to this particular hearing. Using, perhaps the findings out of that case would be helpful in structuring our dialogue with the Planning Commission. Having come from other, municipalities and organizations, findings of fact, conclusions of law. I don't know that I've seen a format that very specifically puts it in bullet point form. Not that it doesn't exist, in my experience up to this point, I haven't seen a clear, concise findings of fact, conclusions of law written out to facilitate this type of a discussion. Not that it doesn't exist, I just don't have a good example in my mind to follow.
And I think you could probably work with your legal counsel and he could help you get through that. I mean, that's up to you. How you approach that, but so is there any more input or comment from the city?
I don't believe so. No.
Mr. Chambers, do you have anything you want to say in response to that?
Yeah, two things. Number one,
You may need to get near a mic.
sorry. First off, so that there's no confusion, my reading of the case requires written findings and written conclusions, not simply findings that are on the record that someone can go back and cherry pick out what they want to take, this comment, that comment. So if we're going to go through this dialogue one more time,
You don't need to, because I agree. And that's why I raised the point of you can't expect the reviewing entity or individual to go back and listen to the record and determine or decipher based on the conversation what specifically they relied upon in making findings of fact and conclusions of law.
And the second thing that I want to comment on, and this is beyond the scope of this appeal, but it's just an observation from someone. For the life of me, I don't know why the North Logan City Council wants the Planning Commission to have a public hearing and invite error into the proceeding on a conditional use permit. And the ordinance specifically says the Planning Commission will hold a public hearing. Well, if you hold a public hearing as opposed to a public meeting, I mean, and if people don't understand that term, there is a difference. I know staff knows. The Planning Commission meeting is a public meeting, but it's not a public hearing. But they've indicated they want to have a public hearing. And out of that public hearing, you get comments that have nothing to do with the conditional use permit. You get it on the Airbnb, or who's going to live in the primary residence or the secondary ADU, or the primary ADU, the secondary residence, back and forth. What the parking is, snow removal that I've got problems on my street, none of the issues that it just invites public clamor into it. And quite frankly, I think staff ought to go back to the city and talk to their legal counsel and seriously consider removing the public hearing requirement, because it's going to taint every one of these. Anytime you have a public hearing on a conditional use permit, it's going to taint the entire thing. And listening to the record on this was painful because it was just a lot of off point discussion that had nothing to do with it. I still think, staff read the ordinance and applied the ordinance and found that it met the meaning of the statute. I think there's evidence in the record to support the granting of the ADU, and I'd encourage, I can tell you're not going to go that far, but to me, there is information in the record that would support the granting of the ADU under this ordinance.
Thank you.
I was just gonna clarify one thing.
I think I know what I need to know to address what's before me. So I think we can go ahead and conclude. What I'm going to do is I'm still going to put together a written decision. I think it will be helpful for everyone involved. I think this issue needs as clear of a record as we can create. I think it will be better for everyone's interest going forward. This is something, given the confusion in the code, I think could be the subject of a lot of litigation. I hope it's not, but so I think it's important that I have something in writing, and I will get that done. What's the date this Friday, the 10th? I'll have it out by the 17th of March. All right. Thank you all.
Thank you.